And we are back with David Daggett with Daggett Schuler Law, talking about your options with personal injury law. We're taking your questions. Doesn't have to be about personal injury. He can, answer all kinds of law-related questions.
You can stump the lawyer if you want.
See if you can do that. All right, but we have a whole bunch of questions. So here's the first one. What's the difference between a personal injury like an injury at a Target or an injury in a car accident, other than the obvious difference that you got hit by a car?
So they're the same principles. They come under negligent law, the law of negligence. And what you have to show is for the other side to be at fault, they have to have breached the standard of care. It's very easy in an auto case that if you run a stop sign, you have breached your duty to the other party. In a Target, if there's a spill on the floor, the Target employees knew or should have known it was there and did not do anything about it. That's the stop sign that got run when you slip and fall and get hurt. So you have to prove that case just like you would in an automobile accident. Here's the difficulty with those type of cases, is in an auto accident, you are much more likely to have witnesses. You have a police officer that investigates it, and that's a witness. And there are defined rules and parameters that people have to follow when they're driving a motor vehicle. You have yellow lines, you have stop signs, you have red lights, you have that sort of thing. In a store like Target, or I'm not picking on them, but that was the question, you don't have those rules quite as defined. It's much more subjective. But the question is did they breach a duty to a person in the store that results in an injury? You have to prove that.
The burden of proof is on you.
The burden of proof is always on the injured person. And you have to prove that they metaphorically ran the stop sign.
All right, what about this? Because we were talking about this in the break. We are one of the 4 states that have contributory negligence.
Yes, contributory negligence. Contributory negligence is an ancient law. North Carolina still has. It means that if you are as little as 1% at fault, the law is any at fault.
So then does that mean I'm driving the car, I'm 1% at fault?
No, not driving the car, but you're driving the car and you do something wrong. Now, doing something wrong is not keeping a proper lookout. And the insurance company will use that against you every time. If you were keeping a proper lookout, you would have seen that person pull out in front of you. If you were making a proper lookout, you would have seen that somebody wasn't slowing down for the other stop sign. If you had a proper lookout, you would have seen the person wasn't stopping in the intersection. Now,
that would make me mad.
Those are the extreme, but we have what's called contributory negligence. And contributory negligence completely bars any recovery. That differs from most states that have what's called comparative negligence. In comparative negligence, there's different laws in different states, but the variation basically is if I'm more at fault than you, then I owe you the percentage I am at fault.
Okay. All right, this person says, how would you know how much your accident with injury is worth?
Well, there are objective parts. There's medical expenses, there's lost wages, potentially future lost wages. There's pain and suffering, there's permanent injury. Lots of times, particularly when your ability to earn income in the future has been impaired, or your ability to take care of your family in the future has been impaired, your ability to participate in recreational activities has been impaired. All those things are subjective. You need somebody with experience in those areas to help advise you, who's been there before and can help you evaluate that situation.
And seeing what the precedent is for those types of things.
And what the experience is.
Okay. This person says, what happens when you have an accident and the other driver has no insurance?
So that happens quite a bit. In North Carolina, insurance companies are required to offer what's called uninsured motorist coverage. Now, what happens in that situation, and where people need to be careful, is if you get hit by an uninsured driver who's at fault, your uninsured coverage steps in their shoes, your insurance company is now against you. You got to be real careful.
And yet if you don't have that uninsured coverage.
Right, now you do have it unless you've signed a waiver saying you don't want that coverage. That's what you have to do under the law. The law has a couple loopholes there, but most people have what's called uninsured insurance coverage. By the way, that covers you in hit and run situations also. It's very important coverage to have.
Okay. This person is asking, how do you collect personal injury claims from a closed business?
So a closed business, it can be very, very difficult. What you have to do is follow the path of ownership, follow the path of the money. You know, there's an old saying, always follow the money. Follow the path of where the money is. It could be that there's still insurance coverage on that business, even though the business is closed. It also could be, if there's no insurance, the business is out of business and disappeared or bankrupt. It could be tough luck. But usually there's a path to follow between insurance, between the ownership, between proceeds from the sale of the business.
Okay, all right. So what we're going to do, we've still got some questions to hit. We want you to get your last minute questions in. We've got one more segment with David Daggett, so you can text us 336-379-5775. Let's check the forecast. We'll be back in a minute.